Good evening, friends. When we started off the journey of 75 years of celebration of the Constitution of India, I had a discussion with Justice Roshan Dalvi, who has been pillar to the Beyond Law CLC series. And at the back of my mind, I was also having an impression whether we will be able to complete 75 sessions. But God willing, and people like you, we have been able to complete those 75 sessions. And today is the 75th session. Though these sessions will continue, but it will not be under the aegis of 75 years of celebration of Constitution. And we are truly indebted to Justice Roshan Dalvi, who has been a pillar of strength for bringing her vast knowledge, wonderful speakers, and also today one of the speakers, Justice Manju Goyal, has joined this journey as we culminate with sense of this thing, obligations to all the speakers, coupled with the fact that we have been able to achieve what we had perceived. Though the topic also speaks looking backwards, going forward, the experience of an arbitrator. I can also coin it with Beyond Law CLC, that we keep on looking backwards and also forward as to how we can make these sessions more meaningful and fruitful. Today's topic, looking backwards, going back forward, the experience of an arbitrator, from Justice Roshan Dalvi, a former judge of Bombay High Court, would not only give us the insights in respect of the arbitration, but as an overall reflections and mirrors and images in different perspectives. And we had requested, because in Chandigarh, we are also hosting India International Disputes Week 2026. And it is going to be wherein the present Chief Justice of India, Honorable Mr. Justice Suryakant, will kick off and help us to facilitate and understand these perspectives in a different manner, and as to how Chandigarh can also emerge as one of the institutions where people can look upon for arbitration, conciliations, what we speak of third-party resolutions. Already the Arbitration Center in Chandigarh is doing well. This week, from 7th of March till 11th of March 2026, would help us to understand things better. Though I normally don't keep the introduction to so long, but there were certain occasions to do it. And thank you, Justice Roshan Dalvi. And we are also thankful to Justice Manju Goyal, a former Delhi High Court judge, who has joined us. Over to you, ma'am.
Good evening, Vikas, and good evening, friends. Thank you for keeping me in your ultimate 75th session. I thought of our Constitution 75 years ago, speaking about economic justice in the preamble, and 51D, the last of the directive principles of state policy, which speaks about the settlement of international disputes by arbitration. Though this has been there in our Constitution, we have to go a long way to achieve really such settlement. This settlement can be by way of adjudication of an arbitrator in an award and thereafter the court proceedings. It can also be party driven by mediation, and also a mix of both, which we call meet-arb, and which I do quite often, which is more of conciliation under the Arbitration and Conciliation Act. The scenario today, as I see in my experiences, is as is shown in the story. In a class, a professor of adjudications and arbitrations, litigation and commercial law, gave one example to the students. There is an apple tree at the end of the fence of one person, and the tree is grown large and wide. Apples are falling from that tree not only in his compound but in the adjacent compound because it's near the fence. The adjacent owner has sued this owner for compensation because she claims that the apples are destroying her tulips, which are so fragile, and apples are so large and so heavy. The professor gave 2 slots, some students for one owner and some students for another. The students looked up so much of law of compensation and damages and what happens, etc., and commentaries of various books. The other set of students, whose defense was that this is vis major, I can't help it if the apples are falling on your tulips. You can pick them up and take them away. And indeed, apples falling into the backyard of somebody else becomes their property also under judge-made law. So they looked up various commentaries of various authors on torts as well as on contracts and several judgments. And they made a fine presentation before the professor. The professor neither smiled nor frowned, and he only told the students in one line, apples fall in autumn, tulips grow in spring. And he handed them back their projects. This, friends, is the commercial adjudication today. The lawyers, in my experiences, are saying so many things which are so completely irrelevant to the main issue. And as they say, that litigations and arbitrations are not so complex or complicated. They are made complex by inefficient practices. And this is one nice example to keep in mind. To see what is required, and only to ask for that so that you can get it in the best possible time. Now, arbitrations, friends, since we are on that topic, has gone a long way in substantive law. We are on par with any in the world. Our judgments can be replicated elsewhere also. But the procedural law is where we lack. And legislature as well as the judiciary have done its best so far to put us on track. We have to find out whether we are really on track and whether we are going ahead full steam. Now, formally, there was the 1940 Act, which was really a no-gainer. We got the 1996 completely new Arbitration and Conciliation Act under the UNCITRAL model. That also proved to be less than required. Amendments were made calling a spade, and really it was a carrot and a stick, but I would say a carrot and a whip. I thought, and that was the time that I retired as a High Court judge and the Act just came into play, that now we are on velvet and everything will go smoothly as it does in other jurisdictions internationally. They took care of various business principles while drafting that legislation. And things about simplification, things about non-value added items, things about the big things that must be taken up first, etc., were the hallmark of that amendment. But alas, in 2018, it was diluted. It was a big setback because people thought there were difficulties. And I thought those were challenges. They were not taken up. Thereafter, in 2019, again the amendments that came about, and 21, one great thing that could have happened was the Arbitration Council, which has yet not taken over. With the result, it rests with the High Court, and High Court and the Supreme Court have to do a lot of, you can say, clerical work. Now, if you have to get out of that position, because as Mark Twain said, if you're going to do what you have always done, you will get what you have always got. We have to do something different. We have got from the legislature the time bound resolution aspects. From our Supreme Court, from our precedents, we have got procedural fairness judgments. But we have to take that baggage with two things. One is the mindset, and the second is the work culture. These are the two things which, in my experience, is lacking. We have heard of the BSNL judgment of this year itself, where our Chief Justice of India had the courage to call a spade a spade. It was drafting simply complicated clauses of arbitration, which leads to avoidable litigation and arbitration, he said. And he was correct, because that clauses gave jurisdiction to Jaipur as well as Delhi in adjudication and in arbitration. And it would raise needless disputes. This work culture has not changed, unfortunately, but it can with very little extra effort. It doesn't even require legislative drafting and amendments, etc. It may be by High Court directions, that is, practice directions, or by arbitrators themselves. Now, friends, we will look up point-wise from time to time what happens, what should not happen, and what can happen. The very first thing in my experience is the claim itself, which takes up unbounded time. Now, there has not been a single process in law like a plaint or a petition, an appeal, revision, application, where the main process, that is the main application, is not filed before the first application is made to court. In a suit, we have ad interim injunctions applications, but the suit is filed and the documentary evidence is all there. It may be that a couple of documentary evidence may come later, but the other party has knowledge of whatever is the cause of action and whatever reliefs the plaintiff wants. Similarly, in writ petitions, appeals, etc., the main petition or the application is there, but the claim is not there in an arbitration. And in a very finely drafted 2015 amendments, I would have expected that to be, but it has not been. Now, sometimes about 4 months or so go off in this. In one matter, somebody told me that I need 8 weeks. I said, you can take 8 years. It's your claim. I am just waiting for you to come up. But when I had ad interim matters under Section 17 to decide, I said I will not decide unless the claim comes. And pat, the claim came. Even for appointment of an arbitrator, you go without any baggage. And an arbitrator is appointed. The date for the preliminary meeting is not given. It may be taking into account that the arbitrator may not have time at that time. But the preliminary meeting can be fixed anytime in the evening, anytime early morning, and it'll go on for about half an hour. That is not done. Soon thereafter, in the preliminary meeting, the minutes do not show that everything one by one can be done, but which can be done. And when I do it, it has gone off successfully. So, friends, one little thing, and it doesn't require any amendment, that Section 9 matters, Section 11 matters, may not even be taken up without a claim. So far as the arbitrators are concerned, Section 17 applications similarly would fall through. So that half the thing is over, and then only the SOD has to come. In the SOD, I find that despite the 2015 amendments to the CPC, which lay down under various orders 11 to 15A, a very smooth procedure for adjudication of a whole trial, mainly the denials take a backseat for sort of procedural expediency. The law says now, and now is for the last 10 years, for 1 decade, it is our law, that you cannot deny without giving reasons. Denials must be followed by reasons, a very salutary principle. It is not done. I deny, I accept the receipt but deny the contents, and then each time, every time, you say whether this document has to be marked or not. Usually, arbitrations have a contract. The contract is an admitted agreement. There may be some other agreements which are also admitted. Admitted facts don't have to be proved. Admitted documents can be forthwith marked. Certified copies of public records can be marked because they carry a presumption of their correctness. And a chain of correspondence. Formerly it was by letters. Now in our arbitrations, it's by emails. That chain itself can be marked because obviously if you've received an email, you have given a reply, no arbitrator will say that you have admitted the contents. Those will have to be taken together, which are not taken. But if that is done, again, I have found that the process becomes extremely smoothened. After this comes the arbitrator's homework. And I do that homework, which is the best part of the first hearing that I find. Quietly in my chamber, I read up the claim, the documents, the SOD, the documents, and I find out the markable documents, I would say, the admitted documents, the correspondence, which can be taken together, and the issues become very easy to draft. 3, 4, at the most 5 issues will do the job. And they can be done in the second meeting itself. The preliminary meeting has gone off, the lawyers have done their job, the arbitrator has to do his job. And it comes out that those minutes actually rule the roost. Then comes the evidence. Now we have documentary as well as oral evidence. Oral evidence is not always required. Oral evidence of parties invariably is a complete repetition of their own pleadings. Every single time I, as well as the arbitrators on the panel, when I am with a panel, tell them, please do not repeat. It is not going to make your case any better, but it is always repeated. In fact, on this pleadings itself, the party can be cross-examined. It becomes the evidence. Now in commercial litigation, and these are the best practices that we can adopt in international matters, so often the claim, the documents annexed to the claim, and the oral evidence all comes in one go, right in the beginning. The SOD, the documents, and their evidence also comes. And ideally, if you're going to examine 3, 4 witnesses, all their evidence can be just put up. But somehow, I find in my experience that there is a lot of suspicion as to how that evidence has to be molded by reading somebody else's evidence, which need not be in a commercial litigation that arbitrations are. So, evidence, one is ideally with the pleadings. Second is only what is required. Now, if there are documents of witnesses, then of course those documents cannot be marked as admitted documents or anything. They will have to be proved. Those witnesses would have to come and their evidence would have to be recorded, because at least the principles of evidence would have to be maintained, even though the Evidence Act or the CPC may not apply. These are the only few principles that form the bedrock of both these litigations. Another thing is, unlike in the West, where there is audio recording of evidence, we have manual recording even today. The only thing that has happened is that the evidence is shown on a screen. In fact, it's quite distractive quite often, and I would not want that evidence at that time to be shown. But the evidence to be recorded takes up an undue amount of time. And when it is by a narration, it ultimately reads better. It allows the reader, the lawyer, as well as the arbitrator to concentrate on a particular matter in a paragraph. This is how we trial judges always recorded evidence in the courts, and I maintain that I will record it only that way. In one of my arbitrations, somebody said that not a single other arbitrator does that, not even the Supreme Court judges. I said, okay, I'm not a Supreme Court judge. And it has worked very well. I don't see how, if you have to ask the question, when were you born? And I say, I was born on 1st January 2025. I don't write only the answer, but I have to write the question. It is the answer that matters and not the question. But sometimes either the questions are misleading or the answers are evasive. And in that case, in those paragraphs, if we do question answer wise, it comes out very clear. This is my experience as a judge as well as an arbitrator. It works better, it works smoother. Then comes the question of summons for the witnesses who are going to appear. Most of the time, the witnesses would come upon being told, and we say, call your witness. Sometimes parties cannot call, and sometimes they may even pretend not to call, not to be able to call, though it is the witness that they want. And summons has to be served. So the arbitrator would say, all right, you have to get the summons served. And under Section 27, you go back to the court. And a High Court judge has to do this work. Now, this is the work that can be easily given to, say, a registrar judicial who can issue summons. And if the summons are not heeded, a proclamation and a warrant. But this clerical work being done in the court eats up the time of the 34 applications which cannot be outsourced by the court. That will have to be decided by the court, and those applications then take a back seat because the judge is busy doing work under Section 27 and not under 34. So that is something which can be done by practice directions of each High Court. The next is the extension of time under Section 29A. Most of the time it's not required. Most of the time the lawyers are very good and come prepared and finish up the matters, in my experience, in 6, 7, 8, 9 months. There are, of course, a couple of black sheep everywhere, and a couple of such arbitrations go on for extensions. What happens is that there are various judges who take up these extension matters under Section 29A at various times because the assignment changes. They don't know how many other extensions have been given earlier. There is no legislative limit on the number of extensions that can be given. There is no limit, and naturally so, to how much would be the extension, because that should be in the discretion of the court based upon the facts of the case. But what I say is, when there is a duty to extend, there is also a power not to extend. I have not come across a single matter where it's not extended, that you have taken undue time and we will not extend. The legislation says that if the arbitrator has caused delay, then the arbitrator can be removed, but a hearing has to be given to the arbitrator. But I have come across so many cases, mine as well as on the panel with me, and I have heard from my colleagues, that arbitrators are ready and willing and available and able, but one party causes this kind of delay and defeating procedure. That has to be curtailed. And that can be curtailed by not extending, except by saying that now you go on, no further evidence, etc., or whatever the High Court deems fit. This is a great area where just by practice things can change. And that is what I said is the work culture that we have to develop. Once that is done and the award comes, there is evaluation of the evidence by one adjudicator. This evaluation is in our evaluative mediation also. It is neutral evaluation in America. It is just evaluation here. But we see the facts and the law and we understand how things can change in a friendly manner. So arbitration may turn to mediation ideally. In my practice, I have seen that when I finish off the matters, almost in every single matter, I've realized that it could be much better settled now that the parties understand what is their position. I'm sure they do, and the lawyers also tell them that these are our good points, these are our weak points, whatever. And after one thing is over, the mediation can take hold. So what I do is, I don't give the award, I tell them that you come one day, right from morning to evening, and trash out everything. You forget the past, look to the future. You have to keep relations. These are business relations. In some of the matters, these are not only business but also family relations because they are family businesses. And by parties understanding this about what is their case, they would be even better able than the arbitrator to decide what would be more equitable. Because an arbitrator has to see only the record of the case. That is the facts and the law. The arbitrator cannot go beyond. But when there are many matters, the mediator can go beyond. And an arbitrator then donning the second hat of a mediator would work well. And even if at that time the mediation is not successful, I would not say that it's a failure. I would say it has not succeeded now. So that when parties again meet, either they will meet at the time of arbitration or they will remember what they have negotiated in that mediation. And I have been told, actually told by some of the lawyers later on, that certain matters have got settled, either after they have filed the challenge or even before when they have done. So Arb made and con, or Arb con, or Arb made and Arb would also work wonders. These experiences, friends, are tiny ones. They don't call for great brilliance, but they call for expediency, they call for work culture and the mindset. Now, what about the mindset of lawyers? The thing is, the first thing that a lawyer has to do is to see what is best for his or her client. Maybe sometimes that is not seen. That is what was found out in the BSNL judgment by the Chief Justice of India. And the Chief Justice had the courage to call a spade and to say who made them lawyers. It was fine to hear that. But in many of the matters, endless applications to show the client that you're doing some great work does not bear fruit. In one of my great enforcement matters as a lawyer, I'm just digressing a little, I found that the party who had got the foreign award, it was international arbitration, had a lot of hurdles to get the award enforced. I had issued various directions, and even under Section 46 of the CPC, I had called upon the district courts in various jurisdictions to enforce ruling. But the applications were both mischievous and malified. Now, with this work culture, things don't get settled. But unfortunately, these lawyers may not be able to understand that it begets less work for them in future. Because if they are going to finish up those matters, more and more of those matters would come to them. And this is what has happened, I'm told, in Bangalore, in India, in Bangalore, where the mediation center has joined with the High Court, with the Bangalore Chamber of Industry and Commerce. And today I'm told by various mediators and the persons in the Chamber of Commerce that so many of the business people, and there is a lot of IT work there, want lawyers to negotiate and settle. So there is a lot of work, and there you can have a challenge for a different work culture, but which has not yet come up. The mindset also requires client counseling. To counsel the client the right way to get it. And if that was done, this Supreme Court judgment would not have made the implications that it has made. But, friends, where we can go further, in my experience in this mediation which comes after arbitration, is to allow the parties to come up with various sort of out of the box thinking. I remember in More for Less, the book by Sriram Panchu, who was my colleague in college and who is a great time mediator and arbitrator. He has given a very excellent example of an arbitration where there were various contracts side by side and each had to be performed. Otherwise, there is a breach, and when there is a breach, there is compensation because the next part of the contract cannot be performed. So, when there was a breach, it was not because of misconduct but out of misfortune of that party. Their banks, etc., did not give the required loans, and the party did not have funds to manufacture what would be the raw material of these parties who had made the claim. A small time lawyer in a group of big, great lawyers said, why not that we give him the finance so that he can manufacture those goods, so that we can get our raw material and we can then manufacture? And everyone laughed at him. But when they could not settle, they realized that this was the only way. And then they found that when that finance would be provided, it would not be that you get just a loan and get nothing else back. That party agreed that he will take only 25% of the profit to be able to roll back into his business. And 75% he will give back to the party who gave the loan. And everything was settled. Alas, that kind of settlement and that kind of thinking has not come, as I see it. It is only we will settle for 100 or no, we will settle for 85. That is the settlement, but that settlement does take place. Now, therefore, friends, we require some business principles, as I always believe in them, and a great passion for them. One is simplification. Go straight to the main issue, and that settles everything. The the needless applications need not be there. Even in our legislations, these principles are taken care of. Now, for example, for the amendments to the Arbitration Act, the arbitrator will decide. Sharing of these best practices, like the one I told you of Bengaluru, the sharing of best practices of, say, Singapore in international arbitration, where everything comes together the claim, the documents, the oral evidence, the witness, that is the witness statements, is a very fine example to follow. And we are on the diving board. I have told you where the shoe pinches because those are my experiences. But if we are going to have to do something better and we are thinking of our place in the stars, we are going to have to change our mindset and our work culture. And friends, we can talk, I would say, we are marching to the promised land. And while we are marching, we work with modesty, then we claim with authority, and then we praise ourselves with honesty. Because, friends, liberation is not deliverance. Thank you.
Am I there? I can't hear anything, nothing, I cannot hear anything. Please let me find out something is missing. Mute.
Yes, Manju?
Yes, can you hear me?
Yes, ma'am.
Yes, I can hear you.
Okay. Thank you so much, Roshan. It has been a beautiful talk, and this perhaps is the third webinar on the Act, Arbitration and Conciliation Act 1996. And the first, I believe, was more than a year back. That was started by Roshan, and then I followed with another webinar on different points. And this is the third. These and the points do not overlap. That is the beauty of the three. The three webinars are on three sets of different points. Now, what Roshan has said today is sharing of the best practices. True, the sharing of best practices from other jurisdictions will be welcome. But in our own experience, we have different experiences of different arbitrators, and we can share those experiences and we can pull up the best practices, whether we do it together in a forum or it is done by some high court or some supreme court is another matter, but it is an urgent necessity. Those best practices need not be included in the act. As she said, I agree, that can be done by simple practice directions of individual high courts. Now, the new thing that I feel today is mediation after trial. Normally, we understand first you try mediation, and when the mediation fails, you can then go for trial. But this also is a good idea that you have done the trial. Now, everybody or both parties know that what they are likely to get. by way of an award. You see, they are also intelligent people. Both sides are assisted by lawyers. They know which point is proved, which is not proved, how much damages is proved, and how much dues are there, which the arbitrator has taken note of, and the award is accordingly coming in that line. So that is a very good point when the arbitrator can say, now you sit, you know what is likely to come from my pen. Now you decide whether you want my award or you want something else to be done. Now, in this, I will add, there are problems which cannot be solved by adjudication. They have to be solved by mutual discussion and negotiation. So I don't have to discuss here what are those, but everybody knows there are issues which are so, so complicated with procedural law or other things, other factors like, admissibility of a document, proof of a document, and things like that. I recall one matter in which the properties involved were huge, several hundred crores. But when I told them that, look, others may have told you that the adjudication or the court proceedings will take long, you take it from me that it will never be solved by court proceedings, because you will fight up to Supreme Court, and then Supreme Court may remand, and then you will have another cycle of birth and death like that. And eventually you will all not be there. Already there are 3 generations I can see in the cause list, in the title sheet. And there will be more generations added to that list. So this pushed them to sit together, and on the same day, when I uttered these words, on the same day, they of course took the whole day, they came to a mutual solution, which I recorded then and there. So these are some of the things which are apparently looking for adjudication, but can be eventually solved only by mediation. Second, work culture. Work culture has to be added with a mindset. Now, our mindset is that you will get an adjournment. This is the mindset. So the lawyer is working with the mindset that, okay, the date is coming, but I will seek an adjournment. He is not afraid that the adjournment will be declined. And in fact, he is right, because we mostly grant the adjournment. Granting because the other party doesn't object, and the other party also wants the similar kind of leniency. So when I fix that schedule on the first day, that this is the date when you bring the statement of claim, this is for the reply, this is for the documents admission denial, and this is, for trial or framing of issues, they take the dates according to their convenience. But eventually I find even the claimant is a defaulter. The claimant is not prepared with the statement of claim. Now, this is a great anomaly, which I have said earlier in my webinar. And now again, I feel compelled to say that the claimant at least knows what is there in his brief. He can ask for an interim relief. He knows, that what kind of an arbitrator, because the court always asks before appointing an arbitrator, if you are in under section 11, what is the scale of the claim. Generally, I find if the claim is too big, it doesn't come to me. If the claim is too small, it doesn't come to me. So apparently, the High Court judge has assessed before allowing the application under section 11 that this claim is suitable to be put before a former High Court judge for adjudication through arbitration. So that is the point of time when the court should be asking, what do you want and on what grounds? So maybe I do not know how it goes in other jurisdictions like Singapore, but then the claimant is very sure what he is going to plead and what he is going to ask for. And therefore, that is the time when he should be ready with the statement of claim. Whether the High Court calls for it or not is another matter. But he should tell the court, I am ready with the statement of claim. I can present it to the arbitrator right now. So that is one aspect which I will like to highlight out of Roshan's speech. Second, stamp. You see, the stamp duty that has to be paid to the paid on the award is a state subject, and different states have different rules and different rates for fixing of the for calculating the stamp duty. And some states, Punjab and Haryana, for example, doesn't ask for any stamp duty on an award. Now, this is an anomaly which should be resolved. Second, if I have to ask for a stamp duty, at what stage do I call for the stamp? That is a blank there, because in Delhi, stamp duty is paid on the value of the award. So the party cannot file the stamp paper before the arbitration award is announced. In that case, many arbitrators in Delhi announce the award without the stamp duty, asking the party to pay the stamp duty within a specified time. Now, this is not what the Stamp Act prescribes. Secondly, even if you do that, maybe in some cases the stamp duty is eventually paid. In some cases, stamp duty is not paid. So there is a loss of the revenue to the government. I generally insist on stamp paper being presented at the time the award is passed. So I let them know the value of the award a day in advance. And then they bring the stamp paper, which is now available on electronic things. Within a day they can bring stamp paper. And then I announce the award on that stamp paper. But there is a gray area. Even we in Delhi, we differ on various aspects. And some arbitrators feel it's none of my business to call for the stamp paper. Although the Stamp Act says the business is of the person who's executing that document to pay the stamp duty. Therefore, with that provision, I as an arbitrator become responsible to pay the stamp duty. So this is an anomaly which I add to Roshan's speech. And this evidence matter. True, evidence is, and nowadays all email trails, and email trails, once you admit one, the rest automatically gets admitted. There is hardly any case in a commercial dispute where oral evidence at all matters. But I don't know, again, the work culture, that we must not leave any stone unturned. That is the approach of the lawyer, that no stone should be left. I must try my best to win the case. And therefore, all that is already said and not disputed are again said through a witness. And once the witness says it, then we have the rule that if you do not cross-examine, it will be taken to be admitted. So they also don't want to leave any stone unturned. So there is also a cross-examination, long cross-examination, which eventually is not read. When the award when the final arguments are being heard, nobody is referring to that long testimony and long cross-examination. These are some of my what should I say, noticeable points I find in the presentation of Justice Roshan Dalvi. And I think they are very well thought of and well considered points, and should not die here. I think these points should go to the appropriate places so that we have some improvement in the law and in the practice. Thank
Thank
you.
you, ma'am, for both of you for highlighting the anomalies. And I'm just reminded that Justice Ravindran had written a book, Anomalies in Law. And he also did one session with us on anomalies in law. And a lot of those topics, and like what Justice Manju has spoken about, a lot of points which actually are brownie points, and they would help us to facilitate, to plug in the lacunas. But the interplay of arbitration, conciliation, and mediation is a thing which we are all looking forward, where people are actually looking for all these alternative forums. And like earlier at the start of the session, we said that in Chandigarh also we are doing an India International Disputes Week 2026 from 7 to 11th March. There will be a lot of deliberations with a lot of good speakers coming across, including the Chief Justice of India, who will inaugurate this week. And the Punjab and Haryana High Court is going to pitch in all relevant aspects. So all those who can get registered, they have the website. Do register yourself, and it will be a good thought-provoking series. And thank you, Justice Roshan Dalvi and Justice Manju Goyal. The most fascinating part is that both of you, like in Hindi we say, speak in Jugalbandi. That is in tandem. So people actually learn a lot. Thank you, ma'am. Justice Roshan Dalvi, would you like to wrap off?
Thank you. No, I would like to wish you the very best for the Chandigarh conference and wish you a happy Holi.
Thank you. Same to everyone. Thank you.
Good day.